Hello, this is Dr. Hart. The case is Kennedy versus Bremerton School District, decided by the Supreme Court in 2022. This is a breakthrough case for religious liberty, particularly religious liberty in public schools. The facts of the case are as follows. Assistant football coach for Bremerton School District, Joe Kennedy, prayed at the 50-yard line immediately following each game. After some time, he was joined by his players, and then even by players of the opposing team. This went on for 7 years, from the fall of 2008 until October of 2015. The district disciplined him after 3 games in October of 2015, when he prayed quietly with his students. The district superintendent put him on paid leave, and the athletics director recommended that he not be rehired. So basically, the school district was afraid of violating the Establishment Clause and being sued for it, and they were afraid so much that they denied Coach Kennedy his right to pray after each game. Kennedy filed a lawsuit in federal district court, but lost, and he also lost his appeal at the Ninth Circuit Court of Appeals. The question is this: is a public school employee's prayer during school sports activities protected speech? And if so, can the public school employer prohibit it to avoid violating the Establishment Clause? In a 6-3 decision, the court ruled in favor of Coach Joe Kennedy. The court said that the free exercise and free speech clause of the First Amendment protect an individual engaging in a personal religious observance from government reprisal, and the Constitution neither mandates nor permits the government to suppress such religious expression. So in forbidding Mr. Kennedy's prayers, the district sought to restrict his actions because of their religious character, thereby burdening his right to free exercise. As to his free speech claim, the timing and circumstances of Kennedy's prayers during the post-game period, when coaches were free to attend briefly to personal matters and students were engaged in other activities, confirmed that Kennedy did not offer his prayers while acting within the scope of his duties as coach. The district cannot show that its prohibition of Kennedy's prayers serves compelling purpose and is narrowly tailored to achieving that purpose. So the school district failed both tenets of strict scrutiny. It failed the compelling purpose tenet, and it failed the narrowly tailored tenet. What are the consequences for constitutional law? Well, the court's Lemon test and related endorsement test are abandoned and replaced by a consideration of historical practices and understandings. Applying that test, said the court, there is no conflict between constitutional commands of the First Amendment in this case. So there's no conflict between the Establishment Clause and the Free Exercise Clause if you allow Coach Kennedy to pray after each game. So the Lemon test that had been severely wounded already and that was barely alive after American Legion versus American Humanist Society now has been put to rest. Another consequence that we can see is the court really turbocharged protection for conduct that stems from religious prayers, from religious beliefs, such as a prayer, by using free speech clause to protect it in addition to the free exercise clause. So Coach Kennedy and those like him are now protected not just by the free exercise clause, but also by the free speech clause. And we already saw how in 2023, in 303 Creative versus Elenis, the court would turn to the free speech clause to protect expression that stemmed from religious beliefs without even having to invoke the free exercise clause. So once again, a highly important case, a major victory for religious liberty, a loss for those who view the Establishment Clause as requiring a total absence of religion from public schools. Thank you.